Welcome to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We provide information and resources that'll help you decide whether or not you need or want to connect with an outside professional counsel. Perhaps we'll help you determine whether you can handle some issues yourself. If you do decide that you need professional counsel, you'll be better prepared, and as a result, so will the professionals you select. Either way, we hope you'll be saving time, money, and hopefully achieve better results. The Bazar and Associates law firm in East Providence continue to donate their time, their experience, and their insights on the various topics that we tackle. We want to thank them and first welcome David Bazar.
Thank you, Deb.
And also today we have with us a special guest, an associate of David's, attorney Tom Mirza. We
Hello.
understand that you are in general litigation practice, personal injury, contract, civil rights, and you've appeared before the Rhode Island State Supreme Court and First Circuit Court of Appeals, as I read.
That's correct.
Your experience is going to come in handy today on some of the issues that we're going to tackle, so let's get to it. Let me quote. Positively wrong. Unreliable roadside drug tests lead innocent people to plead guilty. This was a recent and gripping cover story in the New York Times Magazine. The short version is that it's about these roadside drug tests that are used by law enforcement in many cities. They've been the sole source of evidence used to convict tens of thousands of being, it's been causing tens of thousands to plead guilty across the country with a false positive. And as the investigation had revealed, and this 19-page story shows, these on-the-spot drug tests are really awful. And they've taken the place of ongoing actual crime labs. They've not been using them, and when they've been proven highly unreliable, and resulted in so many of wrongful convictions, people have been suffering the consequences. And this is one case of many wrongful conviction cases that we're going to be talking about today. It's a springboard for our conversation. We know that the Innocence Project helps to exonerate many, but in the meantime, it has caused havoc for many. They lose their jobs, they lose their homes, they lose their family. So what can legally be done? We are calling in our legal eagles today to help with this. So David, Tom, sometimes it's just a system failure. Maybe it's an honest mistake. What happens when someone's wrongfully convicted?
Well, I'll start a little bit. First of all, the problem that you're discussing was in New York. In Massachusetts, many people remember, had its own share of problems with the crime lab, which was a state crime lab with a technician or a person who worked there was not doing their job correctly, and a lot of information was being given out that was incorrect, and people were being convicted incorrectly as a result. So what can the person do who's been convicted inappropriately do? Well, they can file motions to reopen their case, have the conviction set aside, and certainly move to expunge any record that exists as a result of that. Of course, that does not take you back in time to set aside all of the issues that may have arisen in your life as a result of this inappropriate or unfounded conviction.
And when there is a story about, in this one case that was detailed, this person was in jail for a very long time before it's finally overturned and exonerated. She lost so much time, lost her family, is there any compensation for that?
Those lawsuits are very difficult, and one of the reasons we asked Tom to come in today is because he's had some experience with some of those types of situations.
So let's use that as a springboard. Okay, Tom, you have a couple of stories to tell. Please
well,
share
civil
them.
litigation against the state as a result of these types of activities, like David said, is difficult. When I first started practicing, the attorneys told me that the king makes it very difficult to sue the king.
Yes.
So in a lot of states, in most states, there are certain types of immunities that are granted to state agencies, police departments. Prosecutors are almost completely immune. Not completely. Judges are. So looking back on these cases, you have to determine the nature of the mistake. Was it simply negligence, or was there some knowledge of the fact that this information was incorrect? And that allows you to build a suit that gets you beyond the immunity issues that all litigants face. They can be lengthy, expensive, and oftentimes litigants are beyond it and don't always look for compensation. The bigger cases you see in the headlines are those that, one, make the headlines, and two, are addressed immediately with the governmental agencies that are involved, and those are usually more effective for those who are wrongfully convicted or incarcerated.
In Rhode Island, sovereign immunity, as Tom's referring to, under the case of Becker versus Bowden, abrogated sovereign immunity, but invited the legislature to create a cap on what the government might be responsible for as a result of its negligence. So in certain negligent cases, there will be a cap on what you can recover for damages, whereas civil rights cases can be brought against governments and employees that would not have those same caps, correct?
Right.
And that's often why you'll bring a civil rights action in federal court against the
Correct.
state.
For the average person who is victimized by this false positive and doesn't know any better, doesn't have the resources, maybe it's someone who is in minority, maybe someone who's just not well educated, doesn't know the system, doesn't know whom to call, do they get a fair shot at, unless the Innocence Project happens to uncover or follow or watch them, what chance do they actually have? That's not a rhetorical question. Would they have a fair shot at having some sort of restitution made?
It all depends on the facts of the case. There's a big difference between, you don't want governmental employees to be walking on eggshells in their normal day-to-day duties. So if there are discretionary actions that end up resulting in some of these mistakes, that's a much more difficult hurdle for a litigant. If it's ministerial, where it's a procedure and a policy that's routine across the board and they make mistakes, then liability is a little clearer and easier to establish. What you hope would happen is when there's a determination that the conviction is wrongful, the attorney involved in establishing that wrongful conviction will provide advice to their client to seek additional recourse. But I think you're right. If for some reason the conviction is vacated as just an administrative type process and all of a sudden they're told of this, they may not know where to go to seek any additional redress.
I think that in this story, the reason this became a front cover story of the New York Times is that it represented not just one case, but apparently tens of thousands. And then when they checked how this test is done, and it was done repeatedly, that a third of the time it's incorrect. And as they would investigate it, they say, as I read here, no government agency is regulating the manufacturing of that test, and there are varying results, and they're impacted by such factors as the weather, the lighting, and even the accuracy with which the officers administering it in how they interpret the results. So if this has been going on, and I guess this is not a new test, it's been going on since the 60s, championed further when President Nixon had his crusade or war on drugs. So this is not a new test, it's been going on for decades now. And after all of this, still tens of thousands of Americans are being, across the country, are being accused, and they're getting of these false positives, and they're in
the trick is not having to deal with a wrongful conviction. Defense attorneys all the time challenge the validity of a breathalyzer test. They challenge the validity of a radar gun to determine whether it's been calibrated. So forensic evidence, when it's first presented to the detriment of an accused, is the time to check its validity. That's when you can utilize this information, request of the state to conduct independent testing, and hopefully catch it then.
Right.
Because once it gets in, and once the conviction is in place, all of these other remedies, while available, don't always turn the clock back, as David said initially.
And just to clarify one of the things you said, the Innocence Project really is taking on cases where people have been wrongfully convicted,
Yes.
and it's just to get the conviction overturned. It's not about recouping any money or
Right.
any of those losses.
Right. So, but back on what Tom was saying for a minute, and you were starting to talk about, when there's this pleading guilty, does that then shut down the case so that no longer is that vial going to be going to a lab because plead guilty, you close the book, and it's forever sealed and done?
Absolutely. You also risk that evidence will be destroyed.
Right.
And you won't have the opportunity to go back and determine whether it was a false positive or not.
Yeah, that's absolutely correct. And that's part of the problem of people who go in unrepresented don't really know what their rights are and then plead. And of course, in the courts, the judge is going to go over a rights form with you, tell you everything you're giving up, but a lot of people saying, I just want to get this behind me, and so they'll do something that they probably shouldn't do by just accepting liability or acknowledging guilt for something that they probably weren't guilty of in the first place.
And if the system has its failures with the little vial that caused the problem in the first place, and this is just one kind of case, if someone is in the system that has other failures, i.e. a backed up court system, you have a court-appointed attorney, what are the chances that they're going to say, oh no, please don't plead guilty, we should take this through the whole entire courtroom? Many of these cases, as we point out, plead guilty, never see the light of day in the courtroom. And at that point, are they going to do anything to say, let's press onward?
Court-appointed attorneys have the same ethical obligation to zealously represent their clients the same as retained attorneys. I often get clients who approach me for private retainers on criminal cases who can't afford those private retainers. And I assure them that the bulk of the public defenders that I know are excellent lawyers. They do it on a regular basis. They have resources available to them. And it's not an excuse, in my mind, as to how you're appointed an attorney or where they come from. They have the same ethical obligations to zealously represent them.
And it's a
That's
point well taken.
absolutely true. And the other thing that you sort of raise is, if these cases proceed, a lot of times the evidence is sent out to labs to be checked, and the state has a bit of a problem right now because they're so backed up on getting results back, which can interfere with somebody's theoretical right to a speedy trial.
Due
and
process.
Yeah, and due process and all that goes along with that.
So if we aren't talking about this case particularly right now, or this kind of case about the false positive with drugs, you have an anecdote to share with us as well, as I understand?
Well,
one of many?
There are lots of situations in different kinds of courts that result in wrongful incarceration. One of the cases I dealt with approximately 10 to 12 years ago was a case that stemmed from back due child support, where a gentleman, once you reach a certain arrearage number, and in the state of Rhode Island it's $30,000, it's a civil matter until you get to that threshold, but once it goes beyond $30,000, it can be referred to the Attorney General for criminal prosecution. And in this case, it had gotten close to $40,000 or $45,000, maybe even a little higher on the records for this for my client. They picked him up on the body attachment, which is a civil arrest warrant issued by the family court because of the money owed. They had investigated this money and determined that he hadn't made any payments, and he was put in jail until he could start making some payments on it. And you say, well, how do you make payments when you're in jail? But that's another whole issue. But he told the family court that he didn't owe the child support, but he couldn't really express why he didn't owe the child support. Then he expressed to the court that he had had his parental rights terminated and he didn't have to continue paying child support. Well, there was a mistake within the family court, and they couldn't find any records of his termination of parental rights. So one day I walked into court, and the chief judge appointed me to look into it further. And when we did, we actually located the juvenile file. It wasn't a regular family court file. It was a juvenile file because it was a termination proceeding. And in fact, he was telling the truth. And his rights had been terminated, and he shouldn't have had those arrearages continue to build once his rights had been terminated. So by then, the chief judge automatically recognized the error, released him immediately, but it had been 85 days of incarceration up until that point. So from that stage, it became a legal issue as to the effects of the termination on child support obligations. It ended up in the state Supreme Court. They issued a ruling on how those cases should be handled, and from that point forward, family court judges in the state knew how to deal with issues of child support and termination of parental rights. But again, my client had spent 85 days in jail, and we subsequently filed a civil rights lawsuit against the state that proceeded from that point on.
And may I ask, how long did that have to linger?
It didn't take long
Okay.
because we didn't, all the discovery had done. We knew the facts of the case. It was really just waiting to see how the Supreme Court was going to deal with the underlying legal issues. And once that was resolved, then we were able to come to a resolution with the state of Rhode Island.
And was he made whole? Is there a way to have that actually happen?
You're never made whole.
And you can
Regardless
elaborate on
of the
that.
amount of compensation, very few of us spend time in prison.
Right.
So to say whether you're made whole or not is very difficult.
A stretch,
It's
more
a
than a
stretch.
stretch.
And some of the interesting play in that whole case, from my perspective, is Rhode Island became one of the only states where you now have to petition the family court to terminate child support payments even after your parental rights are terminated. It's not automatic, where in many states it's automatic. Isn't that
Correct. Correct.
And my feeling is that there may have been something in the back of the minds of some of the judges about protecting the state from potential liability and maybe reducing the value of that case.
We're the only
against
state, as far as I know
Yeah.
of, the only state that a person who has their rights terminated has to file an additional request with the court that they stop paying child support. The 41 states that have addressed that issue have all determined that it's automatic, that the support ends when the termination is entered. In Rhode Island, there's another step that these individuals have to take.
Yeah, and Rhode Island, those other states probably didn't have cases potentially pending against them where someone was locked up as a result of having child support obligations that should have been automatically terminated.
So I was hoping that we would have a few minutes to talk about, never mind wrongful convictions and what happens, but what about, in this case, I guess it's an example, there was actually a wrongful accusation, a wrongful arrest. The person shouldn't have been put in jail because of what had happened. I mean,
Correct.
never mind the fact that it carried on. What should someone do from a legal perspective if they think that they've been wrongly arrested? Never mind accused, gone to jail,
Yeah.
and exonerated later. What happens with that?
There's not a lot of civil recourse for someone who's just arrested inappropriately or under incorrect information. Again, it goes back to a lot of the immunities police and prosecutors and judges have, and appropriately so. Mistakes can happen, things
Sure.
can happen. Just being arrested incorrectly or on wrong information, it wouldn't be much of a civil rights case anyway. It's the people who spend a lot of time in jail as a result of inappropriate action on behalf of the state that really should have their cases looked at civilly.
It depends on why they were wrongfully arrested. If it's the police
Okay.
officer acting on discretion based on the information he or she has at the time, that's very difficult. If the information that the officer has results from others' errors, that's a different story, and I have a case just like that now, where an arrest warrant was issued from my client, and the police arrested him based on the arrest warrant, so there's no issues with the police. The question is, why was the arrest warrant issued in the first place? And in my case, it was a mistake by a clerk at the court. That's not a discretionary function, that's ministerial, that never should have happened, and in my opinion, there's liability. If the court had issued the arrest warrant for my client erroneously, and the clerk simply entered it into the system and he or she was arrested, there'd be no liability. But the court issued the arrest warrant for another person,
For the wrong,
for the
it should have
wrong,
been
for the
a
wrong
different
party,
person. Yeah.
for the plaintiff
Oh.
instead of the defendant, and the clerk just assumed it was for the defendant,
Oh.
and he was arrested. And so, very factually based, and it really determines, it's dependent on the nature of the action within the system.
So at times we say that there are occasions when someone can defend themselves. If someone believes that they are wrongfully accused, arrested, can they handle that on their own? Officer, that's not me, don't take me in. Or do they really need to go down to the courthouse, get their one phone call and hope that they can get a hold of a lawyer? Can they do it on their own, or do they need to call a lawyer to make that actually take place in the right time frame?
I don't think you're going to get a police officer to look at the warrant that he has in front of him that says your name on it and convince him, oh, that should have been.
It's not the
someone
officer's duty to do that. That
Okay.
would be disastrous.
Right.
Officers have discretion
Right.
on the
Yes.
scene, but it's usually the facts and circumstances in front of them,
Right.
not the background to why they are being instructed to do X, Y, or Z.
There's no way a police officer could do anything but follow what the information in front of him suggests is accurate.
And the
Okay.
last thing I advise anybody is to get into a debate
Right.
on the merits with the police officer
Right.
at the scene.
When he has something in his hand.
Right.
Suppose now, and there are several other cases that I had been reading as I was looking into this topic, a cop arrests or stops someone and then says, step out of the car, and oh, by the way, that's a rented car. I happen to see that there's a needle on the ceiling, they said the ceiling, the roof upholstery of the car. That's yours. He sees a white speck, that's cocaine, and suddenly there's an arrest on the spot, suspicion of. Could
All
you-
legitimate.
All legitimate. Can you do nothing? Can you not say at the time, this is not me, this is not my car, no, it's him, or it was somebody else who rented the car before me? What do you do in that case?
Two things. You do two things. First of all, you are respectful and cooperative.
Okay.
You do one of two things. You keep your mouth shut, or if you decide to engage in a conversation with the officer, everything you tell them better be truthful.
Right.
So if you don't think you can be honest with the officer, you don't say anything and leave it for another day.
Right. So if it's a rental car and the car wasn't cleaned and somebody else's stuff that was in there, you save it for your attorney to use in defending the case, because if the police officer has reasonable suspicion that this is yours and he's acting as any other police officer would, you're not going to talk him out of it or convince him, so you're just digging yourself a hole.
And the United States Supreme Court just issued a decision about a month ago that significantly expanded the officer's ability to search vehicles on routine traffic stops. So that's
Good to know.
a case that, well, most people won't know that, but I'm sure that that will be disseminated to law enforcement if it hasn't already, so that they know the boundaries to what they can do on the scene of even routine traffic stops.
So you know, when I just cited those two incidents where a person was arrested, it too had a wrongful arrest, a wrongful conviction, and a person who was incarcerated for more years than one can even reasonably imagine.
Right.
Wasn't prosecutorial misconduct, just someone goofed.
There's supposed to be there are safeguards in place in all of these situations, particularly with the pace of these cases. And it's the courts, it's the judges. And most of them are aware as to how long litigants are incarcerated, alleged criminals are incarcerated, and it's, in my opinion, it's their job to keep the pace of these cases moving so that they can come to a resolution in a reasonable period of time. U.S. Constitution says you have a right to a speedy trial. So when I hear of these stories where these cases linger for a long time, I don't necessarily look at the prosecution, I look at the courts and question as to why they're allowing these cases to linger.
Okay, and let's see if we can help some of our viewers with other things that can happen. Suppose you don't really have a legitimate lawsuit that you think that you want to wage against the system that done you wrong. Nevertheless, the outcome has been that the bad news of this conviction follows you forever. And it affects your job, it affected your life, maybe you can't get your family back. But now you can't become a member of the PTA or PTO, I think they call it now. What can someone do? Do they need a lawyer? What can they do so that they at least can have an opportunity to have fair shot at the job, or
Is this
if
a
they've been exonerated?
situation where they were wrongfully
They
convicted?
were wrongfully convicted. They're
And-
not going to sue the
No,
system, but what can they do
has
to
the
make their life?
conviction been overturned and they've been exonerated.
They've been
at that point.
exonerated. Now what?
Expungement. They're entitled to have the records expunged, and therefore, if that's the only thing on their record, they can join the PTO or PTA, coach Little League, and do all the other things that anyone else could do.
That should be done automatically.
Right.
Once the court has determined that the conviction itself was erroneous, part of that determination should also be the clearing of any records as a result of that. That doesn't mean that employers or people won't already know about it and have questions, and that's just a hurdle they're going to have to deal with by explaining the facts and circumstances of the case.
But there are times where you still have to go back and check your BCI record in
BCI?
Bureau of Criminal Information record,
Okay.
and make sure that it's off of there. And so that, as Tom says, people may still know you, and you can explain the situation, and they may know the situation, but certainly double check it to make sure that it's cleaned off, and if it's not, make sure, I would hire an attorney and make sure that gets done.
And it may not matter to some people. They may say, oh, you got off on a technicality, but I still believe you did it, and we want nothing to do with you.
That can be.
So you have other biases you'll have to deal with.
Is expungement something that the person can handle themselves, or do they need a lawyer for that?
I wouldn't operate on myself, so I'd say probably get an attorney, make sure it's done right, because I've heard of situations where expungements are done, but they're still showing up in different places because you didn't follow up and do everything you needed to do as the person trying to get the expungement done, sending it to the police stations, the Attorney General's office, that type of thing.
Now, I'm sure you're good, David and Tom, but what happens on social media? Do you have to then hire a social media representative in the public relations field to go try to, you can't eliminate it, but you can at least repopulate the various sites so something shows up about how it's been expunged, it was incorrectly done, but you know that lives forever. But what
That's when they
case,
have to hire you. Attorneys don't deal with that.
But it is true that social media means that this is going to live forever no matter what else follows.
Right.
Somewhere, if someone wants to dig without too much difficulty, they're going to uncover it.
Right.
That's a tough question.
Yeah.
Because you could just be bringing the issue back to light. Even though you're trying to explain it away, we know how short our attention spans are these days. You might be better off letting sleeping dogs lie and deal with it just as it affects you personally.
Go ahead.
I was going to say, and if you find that there's prosecutorial misconduct, is that something that means that by the time someone's exonerated that they should, for the good of the cause, should they go back and try to have you or someone else fix that situation?
In terms of a civil suit,
Yes.
it really depends on what the damages are that
Okay.
they had and who created those damages because of the different sovereign immunities and immunities that folks would have.
Correct.
We do worry about what happens with the police these days, and regardless of what motivated, we worry.
Yeah.
We hope that this has been helpful to you. We hope you will continue to stay tuned to the Law Matters because it matters to you. David, Tom, thank you so much for
Thank you.
being with us.